In this lecture, we're going to look at the NGRI defense, or the not guilty by reason of insanity defense. Before we start, take a look at this particular defense and some of the definitions, let's address the most important issue before we get started. When are you not guilty, even though you commit a crime? Now, the answer to that question actually takes us back to the beginning of class when we were talking about theories of crime. If you'll recall, one of the things that we talked about was the fact that our country was founded at a time when the classical school of criminology was very important and had a lot of influence on our founders. And the classical school, if you'll recall, according to the classical school, crime is a result of free will. You choose to commit a crime. And that you have intention or knowledge that your behavior is criminal when you choose to commit a crime. And in fact, the term that's used to describe your state of mind is this term called mens rea. It literally means guilty mind. If you have no guilty mind, then you can have no crime. So mens rea is a fundamental principle of criminal law, and it's part of two principles of crime. In criminal law, there are two principles. There's a mental element and there's a physical element. And mens rea is the mental element. The physical element is the behavior itself. But mens rea is a term that we use to describe the person's mind at the time they committed a crime. If you have seen any statute that describes different criminal behaviors, you'll see that there's mens rea in many, many descriptions of crimes. So for example, first-degree murder often talks about intention, which is obviously your guilty mind intended to do something. You'll see second-degree murder, they talk about malicious mind. You'll sometimes see the terms in statute, things like knowingly, recklessly, or purposefully did blah, blah, blah. So mens rea is a central component to our belief about crime. And not guilty by reason of insanity, then, is a plea that suggests that at the time the person committed the crime, they lacked a guilty mind. Okay? You're not arguing about the physical element, the behavior, but rather the guilty mind. So let's take a look. Our public view of NGRI is pretty negative. If you look at surveys of the public and they ask the public about not guilty by reason of insanity plea, a lot of the public believes that it's a way to get out of punishment. So they don't really support it, at least in principle. Of course, some of our views about NGRI come from cases that get a lot of media attention. So this week you're going to be looking at Andrea Yates' case. At the time that Andrea Yates murdered her children, that case got a lot of media attention, and people knew a lot about this particular case. And so people's views about NGRI often get formed based on these very high-profile cases. And so, for example, most people think that NGRI is used mostly for murder cases, when in fact it's not. Sometimes there are cases where everybody knows that NGRI is the right answer, and yet the justice system doesn't necessarily follow through on that. The other case that you'll be looking at this week is the case of Ralph Tortorici. And in this particular case, everyone who worked this case knew that Ralph Tortorici was insane, however you define it, at the time that he committed his crime. But you'll see that justice wasn't necessarily served. So let's take a look at how we think about NGRI and the evolution of our thinking over time. In the 14th to 16th century, insanity was viewed as mainly good versus evil. And so the test that was often used to determine if you were insane had to do with your ability to understand the difference between good and evil. So it was more of a religious kind of test based on religiosity. Later on, though, like in 1724, you had the first attempt by the courts to actually define insanity. In this particular case, The defendant had attempted to assassinate a British lord. And the courts had to struggle with a definition to describe what insanity was. And here's what they came up with. The jurors in this case were told to acquit if they found the defendant totally deprived of his understanding and memory, and doth not know what he is doing, no more than a brute or wild beast. You can see there's a shift here away from the religious explanation, and this is often called the wild beast test of insanity. So basically what you're saying is the defendant has no more cognition or no more ability to know right from wrong than a wild beast would know. So it's the wild beast rule. Now we're going to fast forward to the 1800s, where the first real rule was established, the MacNaughton rule. So the rules that I'm going to be talking about from now on are rules that you still see in modern times. The ones on the previous slide we don't really use anymore, but the MacNaughton rule is still used today. So Daniel MacNaughton was a woodworker, and he believed that he was a target of a conspiracy involving the Pope and the British Prime Minister Robert Peel. At least initially, MacNaughton was really distressed. He tried to leave England and travel Europe to try to get away from the Pope and the Prime Minister, but in his own mind, the Prime Minister and the Pope were following him, and so forth and so on. So in 1843, he returned. He traveled to 10 Downing Street to ambush Prime Minister Peel and to shoot him. And he fired off a shot. It missed the Prime Minister, but it killed his secretary. MacNaughton was tried and sent to a mental institution where he spent the rest of his life. Now, this was a very high-profile case in England at the time, and there was this feeling that MacNaughton had gotten away with something. Queen Victoria was upset, and she demanded that the House of Lords come up with laws to protect the country from what she called madmen who could kill with impunity. And so the House of Lords came up with what we call the MacNaughton rule. So what is this rule? According to the MacNaughton rule, the conduct is that the behavior, the murder, shooting the gun, is the result of a disease of the mind. So to the extent that the defendant did not know what he was doing. If you think about what was going on with Daniel MacNaughton, he felt that the Prime Minister was out to get him, and he had lots of evidence, and of course the evidence is in his own mind. I mean, he tried to escape, but the Prime Minister kept hounding him, and what do when somebody is trying to kill you? In self-defense, you might try to get them first. So the MacNaughton rule says that the defendant did not know what he was doing because of the disease of mind. Or, and this was the other piece to the MacNaughton rule, is they did not know what they were doing was wrong. Okay? So you either didn't know what you were doing, or you did know what you were doing, but you didn't know that it was wrong. So, for example, because of your mental illness, you couldn't tell right from wrong. God is telling you to kill your children. And so why would God tell you to do that? You need to do what God tells you to do. It's not wrong if God tells you to do this. The interesting thing about the MacNaughton rule is, as I told you, Queen Victoria was upset, and she said, and so she ordered the House of Lords to come up with a definition to protect the country from this madman. But in reality, if you think about it, Daniel MacNaughton would have gotten an NGR, still been found guilty by NGRI, using the rule that bears his name. So this is the first of the modern definitions of insanity. Another piece of the insanity plea has to do with what we call the volitional prong. Oftentimes when they talk about the disease of the mind and knowing right from wrong and what goes on in the mind, that's often called the cognitive prong, so, having to do with cognition. The irresistible impulse is what's called the volitional prong. Volition is your behavior. And so what this suggests is that you knew what you were doing, but you couldn't stop the impulse. So in other words, although on some level you knew it was wrong, something about your mental illness kept you from being able to stop yourself. So how can you tell if somebody couldn't stop themselves? An irresistible impulse. By the way, you'll see the volitional prong in some of the state statutes. And so you're going to have to figure out how to determine whether or not somebody couldn't stop themselves. And the rule that you see in the states that have the volitional prong, they often use what's called the police at the elbow test. What that means is they use the criteria basically saying that this person could not have changed their behavior even if the police were standing right by their elbow. In other words, knowing that they were going to get caught for their behavior, they could not alter their behavior. And so think about it. What kinds of criteria would you use to see whether somebody passes the police at the elbow test? Well, for example, if they did something to hide their crime, that suggests that there was a lack of impulse here. They could. If the crime is particularly messy and you leave all kinds of DNA evidence, there's no attempt to hide yourself, you know you're on camera and you still do it, you might pass the police at the elbow test. What you see is that the volitional prong, this particular piece of the insanity defense, is what's often eliminated in many states that define insanity. So very few states include the volitional prong, but there are some, okay? So the volitional prong is the one that kind of is more controversial, and it may be in some states and may not be in others. It's certainly not in the McNaughton definition. The next rule is what's called the Durham rule. This comes from a case that didn't really get a lot of public attention. This is a case of Monty Durham. He was released from the Navy in 1945 because of mental illness. 2 years later, he tried to commit suicide, and he was placed in a mental institution where he got worse for a time, but he was released after a time. In 1951, he broke into an apartment and entered and was caught and was going to court. Now, despite the history of mental illness that Monty Durham suffered, the judge didn't allow him to plead not guilty by reason of insanity, and he was found guilty. But in 1954, the appeals court overruled the conviction. And that court re-examined the McNaughton rule and felt that it was a bit out of date, and they created a new standard. And this new standard was called the product test. And what this particular rule suggests is that the accused is not criminally responsible if the unlawful behavior was the product of a mental disease or defect. So the criminal behavior was caused by, is a product of the mental disease. And in this particular rule, they've sort of modernized the definition of insanity, and they're also bringing in mental health professionals to help determine whether the behavior was a product of the disease. Okay. Next, you have the Ali-Bronner rule. The Ali-Bronner rule, by the way, Ali is the American Law Institute, and we squished the Ali and the Bronner rule together because they're virtually identical. The American Law Institute, there was a lot of criticism of McNaughton, which was used pretty widely in this country. And so the American Law Institute tried to come up with a rule that was slightly different, that covered more. According to Ali, at the time of the conduct, at the time of the behavior, as a result of mental disease or defect, the person lacked substantial capacity to either appreciate the criminality of the conduct, mens rea, or conform his conduct to the requirements of the law. You see right here, the Ali has the volitional prong. So not only you have the cognitive piece right here, this is the cognition, and here's the behavior. So Ali then has the volitional prong in it. The Ali rule, when it came out, gained lots of supporters. They liked the fact that the word substantial capacity, they felt that it was flexible enough for the courts. And the Ali rule was actually adopted by the federal courts and was there for a very long time. So one final type of rule or verdict is this new one called guilty but mentally ill. Now, this is a verdict, not a rule, so that what could happen is you could agree that somebody's mentally ill, but you still say they're blameworthy. So guilty but mentally ill. And what it does is it recognizes the presence of a mental disorder. However, it says you're still guilty. Now, a lot of people like this. It's like, oh, we can hold people accountable. But it really makes no logical sense because there is no mens rea. What this particular verdict says, yes, the person lacked mens rea, but they're guilty anyway, which is really flying in the face of the way we define criminal behavior. However, many states have adopted this potential verdict for NGRI cases. And the reason why we have guilty but mentally ill, by the way, is that you saw this verdict crop up after the Hinckley case. And we'll get to that in a little bit, but as you may or may not know, President Reagan, there was an attempted assassination on his life, and Hinckley was the person who did it, and he was the one that the country was really upset about his not NGRI plea and defense, and so you got this verdict. But it really doesn't make any sense, to be honest with you. So before we go on and talk a little bit more about the Hinckley case and what it did, let's take a look at the state insanity defense laws. So you've got these different rules that we just talked about. Ali, you've got the McNaughton, so forth and so on. Let's take a look at different states and how they have decided, which rules they've decided to choose. Now, one of the interesting things when you do stuff like this is you're sometimes a little bit surprised at what certain states have adopted. Okay, conservative states, you might think, oh gosh, they've picked the most conservative rule, whatever, and it's not necessarily true. So let's look at this. This is shows every state, and you can see that McNaughton then is MN, Ali is the American Law Institute, and the guilty but mentally ill, GBMI defense, is GBMI. Okay, so here's your insanity test right here. So look, you've got Alabama, who's picked the McNaughton rule, and Alaska, who has McNaughton, but they've altered it a little bit. So only the nature and quality prong. So people have kind of picked up certain parts. Here, Arkansas is Ali, but they got rid of the substantial piece. Here is one. Colorado has McNaughton and added the volitional prong. Okay. So if you go through, you can look at all of these different states, and you can see that these very old definitions of insanity are the ones that are by and large used by the courts. Let's look at what Wyoming has. Texas, look, Texas has both the McNaughton and the volitional prong, so the irresistible impulse. Wyoming has Ali, which, remember, includes the volitional prong. So it has both the mens rea piece, the lack of mens rea, and the volitional prong, and Wyoming has that. You see here at the federal level, I told you that the federal courts originally adopted the Ali, but they went back to the McNaughton after the Hinckley case. Okay, so, and here, up in this column here, you can see some of the potential verdicts. So some states, see this NGBI, some states decided to say, you know, we still need to keep our NGRI, but we're going to name it something different. Instead of saying not guilty by reason of insanity, it says not guilty but insane. Okay, So they're just slightly changing the terminology to make themselves feel better, I guess. Um, and so in this column right here, it's treatment, whether or not the state requires treatment once you get NGRI. So if you get in Alaska, it has both verdicts. If you get off and you're found not guilty, then we can treat you or not treat you. But if we find you guilty but mentally ill, we must treat you. Okay. I didn't happen to notice Wyoming. Discretionary. Okay. Okay. So this gives you a little bit idea of how different the states are. So let's go back to the Hinckley case. In the 1980s, Hinckley was clearly suffering from schizophrenia, and he attempted assassination of President Reagan. As you know, he hit but did not kill Ronald Reagan, and also hit his press secretary, and his press secretary was paralyzed for life. Hinckley was found not guilty by reason of insanity and sent to an institution where he spent a very, very long part of his life. I think he just recently, in the last couple of years, was released. However, the public was incensed that this person got an NGRI. And so there was a real clamor to change our insanity rules, and specifically at the federal level, because remember, the federal level, the feds cannot make the rules for the states. The states choose their own rules. But the Insanity Defense Reform Act referred to the federal government. In 1984, they passed the act, and they made it more difficult for federal cases to be acquitted using the NGRI proof. One of the things they did was they shifted the burden of proof. Before, it was the prosecutor that had to prove that the person was not insane. Now the burden of proof got shifted to the defense. The defense has to prove that they are insane. Okay? They eliminated the volitional prong. So they went back to McNaughton. Remember, the Ali had the volitional prong. And then they added another category, like we said, saw not guilty only by reason of insanity. So it's sort of a grudging admission that the only reason this person is not guilty is because they're insane. And they limited the role of experts, that the experts can play in the trial. You can't really the experts could not give an opinion of the mental state at the time of the crime. That was left to the jurors. I should mention that in the 80s, in response to the Hinckley assassination attempt, 3 states abolished the NGRI completely, and that was Idaho, Montana, and Utah. So that defense is not even allowed in those particular states. The federal test of insanity now, you must present clear and convincing evidence. Okay, clear and convincing. It's not beyond a reasonable doubt, but clear and convincing is a higher standard. That at the time of the act, as a result of a severe mental disease or defect, you were unable to appreciate the nature and quality of the act or the wrongfulness of the conduct, which is pretty much McNaughton. Okay. The 3 pieces, right? These 3 pieces, as a result, unable, or the wrongfulness, is pretty typical McNaughton. But this piece right here was added specifically. It's the criteria that you use in order to make this decision. So, how often is this defense used? I have to say, I'm going to pull a rather old study here, and there's a bunch of reasons for this. For some odd reason, and I don't know why, researchers were very interested in the insanity defense during the 80s, I guess possibly because of the Hinckley case. They were very interested in insanity during the 80s and tapered off in the 90s. And nowadays, if you look at who's looking at NGRI defenses, you see that there's just a lack of interest, and I'm not quite sure why. But this was a study that was done, supported by the National Institute of Mental Health. And they were looking at how often NGRI cases were occurring throughout the country, because we didn't have any data on that. because, each state does things differently and separately, and there was no national accounting for it. What that study found was that NGRI cases, or insanity defense cases, constituted less than 1% of the court cases in the country. So it's a very rare, it's rarely attempted by the defense. And interestingly enough, so it's not a defense you usually pull out. So you might think, well, once they pull it out, though, they're typically going to be very successful. Well, the reality is they're not. Only 25% of the time are they successful. So not used very often and not very successful when they're used. Even though in all of the cases where the insanity defense was being used, 90% of those cases were clearly diagnosable. The defendants, the accused, had a diagnosable mental illness. And among those cases, again, this fits, kind of giving some data to public perceptions. Even though the public thinks that NGRI is most often used for murder, the NIMH study suggested that only 50% of those people had even been indicted for a violent crime. So really half of the crimes that in which the insanity defense was being raised was not even for a violent crime. And only 15% of the sample was murder cases. So you can see that it's not typically used and it's not typically successful. However, the public views typically suggest something very different. What the public thinks and the reality is quite different. So let's take a little bit of a shift here and talk about jurors and when they are dealing with insanity defenses. What we have found is that in the lab and in field studies, jurors don't typically use the instructions for the insanity defense to make their decisions. In fact, for example, there are lots of studies for both real jurors and mock jurors where after they reach their verdict, you ask them to recall the pieces, recall the instructions that you got on insanity. So people have used McNaughton, they've used Ali, they used all different kinds of instructions. And then later on say, okay, tell us the pieces that you needed to use in order to figure out whether or not this person was insane. And what you find is that jurors don't do real well at recalling what the pieces of their insanity definitions were. So although states have the definitions, the jurors don't seem to be using them. Also, studies have shown that jurors spend very little time discussing the instructions in trying to figure out whether or not the person was insane at the time they committed the crime. So what's going on here? Well, it turns out that jurors, what we think is going on is jurors don't really pay a whole lot of attention to the instructions because they think they have their own theories of insanity, their own implicit theories, and they're like, I know insanity, I can figure out insanity. And so, for example, sometimes you'll see there are studies that have been done that show that jurors will be swayed by how heinous the crime was. So the more heinous the crime, the more likely they are to buy into the insanity defense. But if you recall, none of the definitions of insanity had anything to do with heinousness. So what jurors are probably using is their own implicit theories and their own attitudes about the insanity defense, which comes again from our public attitudes towards the insanity defense. And survey after survey shows the same thing. The public thinks that it's used often and it's very successful. So the public always overestimates the frequency with which the insanity is raised and the success. They are also likely to view the insanity defense as a way to escape punishment. The person, they understand that the person is going to go to a mental hospital, but they see that as escaping punishment. Their knowledge often about insanity defenses are often limited to high-profile murder cases. So when they're asked to give an example, they're typically going to give an example of a high-profile murder case. The only thing that they get correct is that they do correctly identify the disposition of an NGRI case, that the defendant will go to a mental hospital, not to a prison. But only 25% know that release from a mental hospital is contingent upon public safety. As you know, in the criminal justice system, release is contingent on you serving your time. So if you're sentenced to 10 years, you will serve 10 years, or maybe a lot less, depending on your behavior in prison. But if you're found guilty by NGRI, you could be kept in an institution forever. So you cannot be released unless the public is safe. And most of the public does not realize that. And so in their opinion that it's a way to escape punishment, they don't realize that many NGRI, people who are found NGRI actually spend more time institutionalized than if they were to go through the criminal justice system. Okay, so I've given you a flavor of the NGRI, and before we end, I want to talk a little bit about some other unique defenses. These are not NGRI defenses, but what we call diminished capacity defenses. Diminished capacity defenses, you're not trying to get a not guilty verdict. What you're trying to do is say that there are some unique circumstances that surrounding the crime, and that the defendant, the accused, had diminished capacity. Okay, so that diminished capacity could be diminished capacity to tell right from wrong, diminished capacity to alter their behavior. So they had some kind of difficulty. And it's not used to find the person not guilty, but it's used to get some, to reduce a sentence, for example, at sentencing, or for jurors to yield some mercy. So for example, if a defendant or accused was accused of murder and the prosecution might be shooting for first-degree murder, the defense might be raising a diminished capacity defense in order to get a lower verdict, so second degree or manslaughter. Okay, so, and obviously a second degree murder verdict or a manslaughter verdict will mean a lot less time in prison than first degree. So the diminished capacity defense will be trying to get a reduced sentence. So let's look at a couple of diminished capacity defenses. The battered women or the battered child syndrome. This particular defense has been used primarily in criminal courts by the defense. And it's a variation of the self-defense claim. What you have is these are situations where a woman kills her husband, her spouse, or a child kills a parent. And what they are claiming is diminished capacity because they were victims of abuse by the person that they killed. So oftentimes with women and with children, when they actually kill their abuser really isn't hitting them at the time. The abuser often is asleep. That, you know, they then go and get a gun and kill that person. But what they're doing is saying is that because of the abuse, this person had diminished capacity and was unable, because of the years of abuse, to feel safe. Both of these have been increasingly used. It seems to be a little bit more successful for children than for women, but you see it more often in this country. This particular defense, if you're going to try this diminished capacity defense, will require expert testimony to explain to the jurors why you might feel unsafe when the person who's beating you is asleep. Okay, so this is one diminished capacity defense. There's another. By the way, diminished capacity defenses are kind of interesting. You can use any diminished capacity defense you want. But the judge is going to have to allow it to be used in trial. So here's one that was kind of interesting. It's the premenstrual syndrome defense. Okay, and this is connecting the menstrual cycle and violence. So the idea here is that because of the time of month, you were not as responsible for your behavior, and it led to violent behavior. The American courts have not really accepted this as a diminished capacity defense. If you raise it in the United States, chances are the judge won't allow it into court. However, it was successful in England. This woman backed over her fiance and then ran over him again, and then backed over him again and ran over him again. And she successfully used that, was allowed to bring in the premenstrual syndrome defense into the courtroom. So the judge allowed it there. Another kind of unique and unusual defense, it has been called the Twinkie defense. And this was a defense that was used in 2 cases. So the judge allowed that defense to come in. Basically, what you're saying is that the accused was eating junk food or had some terrible diet that produced a chemical imbalance in the brain that led them to diminished capacity. And it was raised in 2 California cases. One was the Harvey Milk murder. It was raised that his killer had depression and a terrible diet that created this chemical imbalance. The Night Stalker, who was a serial murderer in California, they also raised the Twinkie defense. In neither case did it help them, but the fact of the matter is that the judge allowed it into the case. So that diminished capacity defense was allowed into the trial. Just as an aside, if one case that we're probably all pretty familiar with was the Matthew Shepard case, and the 2 killers that were responsible for his death tried to raise, actually one of them tried to raise a diminished capacity defense. And what they were trying to raise was what a defense called gay rage. What they were suggesting was that the defendant had some prior experience in sexual abuse, and that when he was confronted with a gay man, he had gay rage, and that led to the murder of Matthew Shepard. Judge Donnell did not allow that diminished capacity defense into the courtroom, and so the jurors never heard it. Whether it would have helped or not, McKinney, I don't know, but it can't be entered into the courtroom unless the judge allows it. Okay, so in this section we've covered the NGRI defense, which is different from competence, and I think once you look at the cases, the 2 case studies this week, again, look at one or the other, or maybe both, and try to fit those pieces into what we've learned today.